moving on swiftly to stay with the time, and whilst we're on the theme of the priorities for data protection authorities, I'd like to welcome Armand Heslot, a representative of one of the EU's leading data protection authorities, France's Commission nationale de l'informatique et des libertés, more commonly known as the CNIL. Now, Armand has extensive experience in IT, security, advertising, and data protection, and has been leading the CNIL's Technology Experts Department since 2019, which means, needless to say, that he has been essential in developing CNIL's technological resources that enable it to effectively monitor and enforce EU privacy and data protection rules and establish itself as a leader among European data protection authorities. Armand will now briefly present some of the work CNIL has been doing concerning the digital advertising sector and what's to come in the near future. So, Armand, bienvenue, and over to you.
Cool, thank you for this introduction. We have a short time slot. I'm going to show some slides and then we'll have some room for questions, of course. So we're going to discuss about consent tracking and the digital advertising ecosystem from 2009, since the second version of the EPrivacy Directive to 2029. On next slide, there is a quick summary of what we've been doing in the last decade, very quick. We've had a first recommendation made by the CNIL in December 2013, a recommendation on cookies and other trackers. The goal of this recommendation was to explain to controllers, to publishers, and to the whole ecosystem what was required under the French transposition of the Privacy Directive. We repealed this recommendation in 2009, in July 2019, when we published a new cookie guidelines following the entry into force of the GDPR. This guidelines was complemented in October 2020 by also a new recommendation. And we also had to update our pre-2019 guidelines because we had faced some challenge, the French High Court, and had to modify some of the issues we were dealing with in the guidelines. And then the last milestone is at the beginning of April, when the end of the 6 months tolerance period took place, meaning that since last April, everyone has to be compliant, and we are enforcing those rules. On the next slide, I will be explaining the difference between the recommendation and the guidelines. Basically, the guidelines recalls the applicable obligations. It must be followed by controllers. The guidelines itself does not create new legal obligations, but it compiles all the legal obligations, whether they come from the GDPR or for the French implementation of the EPrivacy Directive. On the other hand, the recommendation explains how controllers can comply with the legal obligations. It gives example of how to comply with the law, and the overall goal is to give legal certainty to controllers. Of course, there are a huge amount of controllers and publishers which are subject to those obligations, to the obligations to obtain consent to the use of cookies. And we face lots of different types of controllers. Some of them are very well aware of their obligations, some of them are not. So we put a lot of effort into building this recommendation in order to clearly explain to controllers, to publishers, what they have to do on the website and what they have to do when they're using cookies, non-insertional cookies. On the next slide, I'm recalling what the CNIL has done since the beginning of the year. We have participated in a dozen webinars on cookies. The goal was to explain to the whole ecosystem what they had to do. More than 900 people registered for those webinars. Those webinars were organized with 27 companies and professional associations. We also built up an FAQ on a website with the most common question that were asked in those webinars. And we're currently discussing with the French TV network and ISP because they're starting to serve targeted advertisement on TV. And we have offered our guidance and in order to explain then how consent should be obtained in this context. So overall, we've really put a lot of efforts into explaining the ecosystem, what they had to do. And of course, this is something that now is quite important since we're reaching the enforcement phase. On the next slide, just a simple slide to recall everyone the interaction between the GDPR and ePrivacy, which are two different pieces of legislation. They overlap, of course, on some items, because in lots of cases, reading and writing information in a terminal will lead to the processing of personal data, and then we have an overlapping of the obligations of ePrivacy and the GDPR. But we also have some cases where privacy only applies. And what is important to recall is that when we're dealing with strictly GDPR, then we have the one-stop shop mechanism and the lead authority jurisdiction. When we are under ePrivacy, there is no lead authority and one-stop shop mechanism, meaning that the CNIL has jurisdiction to enforce the use of cookies. And when there is an overlap, the French law gives us the possibility to either do enforcement based on the GDPR, and then in this case, we'll have one-stop shop and lead authority, or to solely rely on ePrivacy, in which case we will be independent and we do not need to go into the consistency mechanism. On the next slide, I've highlighted the three important decisions that regarding enforcement in the last year. We've had the Google sanction regarding cookies for 100 million euros. We also had a sanction against Amazon for 45 million euros. And we also had a sanction against Carrefour France and Carrefour Bank, French companies, for a total of 3 million euros. In all the cases, the sanction was based, at least partly, because cookies were used and there was no proper consent. What has to be recalled at this stage is that those sanctions were issued before the end of the, let's say, probation 6 months tolerance period that we had allowed controller in order to allow them to put themselves into compliance, meaning that even though those procedures in some cases can be closed, it does not mean that the controllers are fully compliant with the current applicable and currently enforced obligations. But since those sanctions were issued before, they were based on the 2013 recommendation, and it was the non-compliance with this recommendation that was sanctioned here. In the next slide, we'll be seeing what we are intending to do in the next year. In last March, we announced that cookies were one of the priority for enforcement in next year. Just yesterday, it's quite fresh news, we announced that we had issued formal notices to 20 companies for not obtaining a proper consent. We've asked them to put themselves into compliance within 1 month, and if it's not the case, this might lead to fines. We have not released yet at this stage the name of the companies that were issued those formal notices. But if they do not put themselves into compliance and that we open a sanction procedures, we might make it public. This will be settled in the following weeks. Clearly, we intend to target all the actors in the ecosystem, not just the publishers. The publishers have a key role to play in the overall consent collection, but of course, all the actors have their part to do. And so we are fully aware that there are several types of actors with different responsibilities, and we intend to target in our enforcement actions all the type of actors to make sure that everyone puts itself into compliance and that no actor is able to, let's say, put the burden contractually on another actor in the ecosystem without taking part in the global solution. Clearly, our goal is to push the whole ecosystem toward compliance. And well, that's why we have announced that enforcement on cookies will be a priority for next year. On the next slide, just a few elements of our strategy. We intend to target publishers from both public and the private sectors. Of course, we have a very strict policy regarding complaints from individual. The law obliges us to deal with their complaints and to investigate. When we will have complaints from individuals and there is a non-compliance, this will lead to enforcement actions. Also, in last February, we launched a cookie observatory, which is a new tool that some of you might have seen. Basically, we're scanning the websites and analyzing what we're doing regarding cookies. Like, for example, do they drop cookies when you first access the website? Who dropped the cookies? We're making statistics. And based on those analyses that we've made, if I remember, on the top 1,000 websites of most used French websites, we've sent to the top 100 publishers that were relying on third-party cookies a letter reminding them their obligations. And of course, it's not a formal notice, it's not a sanction, it's just a friendly letter to remind them their obligations and to tell them that we've seen that they're using third-party cookies and that we'd like them to make sure that they obtain proper consent. We've also sent a little more than 50 letters to publishers from public sector to make sure that both public and private sector are aware of their obligations and that they put themselves into compliance. And we're thinking about using new enforcement tools, those letters that I just mentioned. It's something new at the CNIL, something we didn't do before. And we're thinking of a various way we can, let's say, have different types of enforcement methodology to ensure that we're able to touch the more controllers that we can. On the next slide, just a short reminder about the technical side. Clearly, consent is necessary for any strictly non-necessary read or write operation in a user terminal. And we're seeing some increasingly a website using other technologies, in some cases thinking that it helps them or it allows them to circumvent their legal obligation. So here the message is, it does not work. Whether you use CNAME clocking, first-party cookies, local storage, session storage, fingerprinting, browser-assigned identifiers, or cohort targeting, in all cases, if you use those techniques, there is a read or write operation in the terminal, and then you still require to obtain a consent when this is used for advertisement. And now a last slide, which will conclude this presentation. What about the EPrivacy Regulation? That will be the discussion of the next panel. First, a reminder, because we have several actors telling us in France that we were applying the EPrivacy Regulation ahead of time. Of course, the EPrivacy Directive is already applicable. It's been transposed into the French law since 10 years now. Regarding the regulation, hopefully the trilogues will start soon. And on this, the EDPB has already expressed itself several times on the draft regulations. There are some things that at the EU level, we collectively, data protection authorities, would like to see change in the draft regulation. And what is very important is that we want to have, as soon as possible, a regulation which will cover every controller, every publisher in the EU with a consistent framework that will apply the same way in every country, and that will allow to have a level playing field. That's it for the presentation. If you have any questions, they're welcome.
Merci, Armand. Thank you so much, Armand, for this presentation, giving a brief yet very clear view on your work. Now, I know we're pressed for time. However, there are a couple of points where, coming through the questions from the audience, a comment from you would be more than welcome. The first one would be whether you could comment about the uncertainties that are being created by differing DPA interpretations at the EU level, and how important it is to make sure that GDPR is applied uniformly.
Regarding cookies, as I said, we have GDPR, but we have ePrivacy. At the EU level and within the EDPB, the data protection authorities are putting a lot of efforts in order to have a consistent application of the GDPR. But that being said, on the ePrivacy side, we still don't have a regulation, meaning that clearly we have different implementations in different EU countries. And in this case, on the ePrivacy obligation, we cannot have a perfect harmonized application. I will just give you one example. All the DPAs are by nature the competent authority under the GDPR, but a lot of data protection authorities are not the supervisory authorities under the ePrivacy Directive, meaning that in some cases, in some countries, our counterparts, the local DPA, is not competent to enforce the national transposition of the ePrivacy Directive, meaning that we just do not have in the EDPB the supervisory authority which is competent for ePrivacy. In the past, there have been some discussion with those other entities, but of course, it's very difficult and frankly to say impossible to have a really consistent application if you do not have a unique regulation, a single piece of legislation, and a single supervisory authority, in this case, the Data Protection Authority. Unless we have a regulation and a clear competency given to the data protection authorities, we will still have discrepancies across Europe.
Now, a corollary of this, you have said that the legality of cookie walls will be subject to a case-by-case assessment. Have you accumulated some assessments now that could be shared with industry for our edification and comprehension? How is that moving?
Clearly, we do not have enough case law at this stage. Of course, enforcement is a process which takes time, especially when it goes through sanctions and it can be challenged regarding the French High Court. At this stage, we do not have any clear recommendation on how can cookie wall used and in which cases they are lawful. What I can tell you at this stage are let's say, the hints that were given by the public rapporteur of the French High Court, because it was one of the items which was challenged in our 2019 guidelines. And basically what the rapporteur said was that, for example, when you're a public authority or when you're preeminent on the market, then in those cases, most probably you cannot use cookie walls. On the other hand, when you do not ask for payment in exchange of a service, and if a user can find some alternatives of the same time of service elsewhere, then in this case, cookie wall will most likely be lawful. But that's all I can say right now. We do not have any case law. We do not have any sanctions yet. This will be up for us and the ecosystem to build in the months to come.
And a final, very brief comment, if you may, concerning your collaboration with other DPAs to share learnings, especially around the work you've been doing with enforcement. How is that working along?
Of course, we have a regular discussion on those items, on those issues at the EDPB. We have several subgroups at the EDPB, and those issues are discussed mainly in the technological subgroup, as well as the subgroup involving fines and sanctions and so on. And we regularly exchange our point of views regarding enforcement and what we're doing. And in some cases, there are also some cases which undergo the consistence mechanism, because some DPA can choose to pursue to open sanctions from a GDPR perspective. And then in this case, we also discuss with our colleagues. But basically, even though we do not have uniform regulation, of course, we're doing our best to have some consistency.
I'm sure we could go on for quite a while, and I hope we will have you back, hopefully at the physical Interact event in the near future. But for now, thank you so much, Armand, for your contribution. It has been very valuable to us. Thank you.
You're welcome. Thank you too.